My topic is calculations and litigation settings. And in addition to being on the NACVA Standards Board, I am the sub-chairman of the litigation subcommittee, which since I've been on the board since June 2018, not 2019, this has been a hotly contested issue. And when I say that, there's been no organization that has prohibited or endorsed a calculation engagement. Next slide, please. If and when is it acceptable for using a calculation report in a litigation setting? That is one of the main issues that we are faced with. And in a calculation in litigation, you must make sure you know your audience. Your audience is key. Is your audience the court? Yes. Is your audience the attorney you're working with? Yes. Is your audience your client? Yes. The decision to perform and disclose the results of a calculation via written report may not be appropriate in a contested dispute litigation setting. The court may attribute less weight to a calculation of value as compared to a conclusion of value. The valuation expert cannot choose to perform a calculation report simply based on the real or perceived benefits of their client. That is one of the issues that we face with doing a calculation report. When you do a calculation report, you specifically put in your report that you and the client agree on certain methodologies and approaches used to perform the valuation. 9 times out of 10 of the calculation reports I've reviewed for other people, they do not adequately put in the I apologize. They don't adequately put in the limitations of the report, what the client and they agreed to. That, in my opinion, is a severe flaw of a calculation report if you're going to do it in that setting. Could you go to the next slide, please? Have calculations been deemed admissible in courts? Yes. The issue of calculations and value and the role they play in a business valuation in a litigation setting has been a contentious topic. In a recent Alabama Appellate Division Court case in Rolling versus Rolling, the court indicated the issue of a calculation of value versus the opinion or conclusion of value goes to the weight, but not the admissibility of the expert. So that leads us to, when is it appropriate to do a calculation of value? There are certain issues that will allow you to use a calculation of value. Number one, when the business owner does not provide you adequate data, adequate information. The business owner will not allow you to interview them or allow you to do the site tour. Those are limitations in a conclusion of value report, but that may allow you to use a calculation of value. There is a time constraint, and the time constraint is not due to the evaluator's schedule. The time constraint could be due to the court's schedule, or if you are hired late, you have to disclose that in your report. That is one of the issues of when it is reliable to prepare a calculation of value. When doing a calculation of value, you have to make sure, as I said, you know your audience. When is it not acceptable to do a calculation of value? When all the information is available. You have complete and full access to all relevant information, the people, and time is not an issue. If your state has already ruled against the admissibility of a calculation engagement, please do not do one. There was a recent case that we were involved in where we represented the dependent spouse in a divorce case. During this case, we prepared a conclusion of value report, but the expert for the business owner performed a calculation of value. We wound up getting that expert's report thrown out of court because all the information was available. He mentioned in his report there was a time constraint. There were no time constraints. The time constraint that he explained during his deposition was the issue of when he was told he had to write a report because we were in settlement negotiations throughout the entire process. Well, the settlement did not come to fruition. We had to go to court, and we got his report thrown out for those two reasons. But the number one reason that we held our hat on was his report did not disclose the limitations between his calculation of value report and a conclusion of value report. He did not agree, he did not put into his report the limitations, meaning what the client and he agreed to, if anything, on the approaches or the methodologies. That was one of the hotly contested issues of the case because the business owner was an overbearing individual that did not like being told his numbers or his approaches were wrong. And that is an actual situation where we prevailed with getting a calculation thrown out. Do we use calculations in our business? Yes, we do. But again, they're for the acceptable reasons to do a calculation, as I indicated. When a business owner is not going to provide you all the information. When they deny you access to the site tour or deny you access to the interview. Dave Miles said today, if you don't have an opportunity to interview a business owner, I'm paraphrasing, then you're not going to be able to get a full picture of that business. That is 100% accurate. If you do not, we all like to think we're good at our jobs and valuing businesses, but we are not the business owner. Each individual business is a different animal, and that is one of the major issues when performing valuations. We have to learn about the particular business. Now, if a member performs a calculation, can the member not take responsibility for the appropriateness of the valuation? The answer is no. In exercising professional judgment, a member's responsibility under the NACVA's professional standards include, but are not limited to, obtaining sufficient relevant data to afford a reasonable basis for the conclusions, recommendations, and positions. Considering the scope limitations, which affect the level of reliance on the information. And 3, exercising due professional care and performance of services, including completing sufficient research and obtaining adequate documentation. The next slide, please. The member or firm signing a calculation report is responsible for the calculation of value. So you cannot make an argument that that the client is not a safe harbor, as such implies that professional judgment could not have been used outside of the agreed procedures under a calculation agreement. This would render a calculation agreement reckless as means of estimating value. The general and ethical standards apply to all professional services performed. The concept that a safe harbor is extended to a evaluator by virtue of labeling and engagement of calculation would effectively hold the member irresponsible for the report and would conflict with several general ethical development and reporting standards which define a member's responsibility under both the calculation and evaluation engagement. They are the most important issues when you're dealing with performing your appraisal or valuation under the standards that we have to adhere to. We have to make sure that we do the standards correctly. That's one of the issues of doing a calculation report. We've seen experts prepare calculation reports because it was the easy answer to do it, or there was a cost reason. And does the cost of a calculation report come into play when determining if it's acceptable? My only answer is your reputation worth potential discrediting if the judge rules against you because we chose, meaning the expert chose, to do the calculation instead of preparing the conclusion of value?